Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. Here's a case every law student needs to understand. If you're doing business across borders, knowing exactly where and when a contract becomes binding can save you thousands in legal fees. Today, we break down the landmark case of Entores Ltd v. Miles Far East Corp. to show you how modern communication changes the legal landscape. To understand this case, we have to look at the parties involved and the technology they used to communicate back in 1955. The case involved Entores Ltd, a company based in London, and Miles Far East Corporation based in Amsterdam. Entores sent an offer to buy goods via a telex machine. Because the companies were in different countries, the big question was which country's laws would apply if something went wrong. Telex was an early form of instantaneous communication, similar to a modern-day instant messenger but using teleprinters. Unlike a letter sent through the mail, a telex message is received almost the moment it's sent. This distinction is what forced the court to rethink traditional contract rules. Entores wanted to sue for breach of contract in English courts. However, you can generally only do that if the contract was actually made in England. If the contract was finalized the moment the Dutch company hit sends in Amsterdam, the English courts might not have had the power to hear the case. The court had to decide if a telex should be treated like a letter or like a face-to-face conversation. Under the older postal rule, an acceptance is binding the moment you drop the letter in the mailbox. This was designed to protect the person accepting the offer from delays in the mail. But applying this to instant digital communication creates a mess, as the sender might not know if the message actually arrived. The court decided that for instantaneous communication, the postal rule doesn't apply. Instead, the receipt rule takes over. This means the contract is only formed when the acceptance is actually received by the person who made the offer. This protects you from being bound to a contract you didn't know was accepted. Lord Denning famously used the example of two people shouting across a river. If a plane flies over and drowns out the voice of the person shouting, "I accept," no contract is formed because the offerer didn't hear it. The same logic applies if a telephone line goes dead or a printer runs out of ink. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Let's look at how the court applied these analogies to the specific facts of the Entores case. The Court of Appeal ruled in favor of Entores. They held that because the acceptance was received on a telex machine in London, the contract was technically made in London. This allowed the English company to move forward with their lawsuit in their home jurisdiction. A key takeaway is that the person accepting the offer has the responsibility to make sure their message got through. If you send an email and get a bounce-back notification, you know the contract isn't formed. You can't just assume the other party received it if you have reason to doubt the connection. This case set the standard for how international business is conducted. It ensured that companies wouldn't be dragged into foreign courts unexpectedly just because they sent an offer. It created a predictable framework for global trade that we still use in the age of the internet. While telex is gone, the principles from 1955 are more relevant than ever in our world of instant digital communication. Today, courts generally apply the Entores rule to emails. An email acceptance is usually effective when it arrives in the recipient's inbox and is available to be read. You don't necessarily have to open the email for the contract to be binding, but it may want to have successfully reached your server. If you're negotiating via WhatsApp or Slack, the read receipts, the blue checks, can be powerful evidence. However, relying on these apps for formal contracts is risky. It's often unclear if a thumbs-up emoji constitutes a formal acceptance under the Entores framework. What happens if you send an acceptance, but the recipient has an out-of-office reply? Generally, if the message reached their system during normal business hours, it's considered received. You should always follow up on critical contracts to ensure a human has actually acknowledged the message. To avoid a jurisdictional nightmare like the one in Entores, you need to be proactive in how you draft your agreements. Don't leave it to a judge to decide where your contract was made. Always include a choice of law and jurisdiction clause. This explicitly states that this contract is governed by the laws of England or whichever region you prefer, regardless of where the send button was clicked. In your offer, you can specify exactly how acceptance may want to be delivered. For example, you can state that acceptance is only valid if sent via a specific portal or signed via an e-signature platform. This removes the guesswork about whether an email or text counted as a binding agreement. If you're dealing with high-value international deals, the cost of a legal review is tiny compared to a jurisdictional battle. A qualified solicitor can help you navigate the battle of the forms, where both parties try to impose their own terms and ensure your interests are protected across borders. The Entores case teaches us that in the digital age, communication isn't finished until it's received. By understanding the receipt rule and using clear contract clauses, you can avoid expensive jurisdictional disputes and ensure your business deals are on solid ground. If this breakdown of Entores Ltd v. Miles, Far East helped you understand contract law better, subscribe to Law Conquer for more case summaries and practical legal education. If this helped, please like the video too. If this helped, like the video and comment with the next case you want summarized. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.